Big changes are coming from immigration. Immigration officers can now deny your green card cases without requesting more information, without sending you a notice. Pure denials. This is new policy, and in this video, we'll talk about who is going to be impacted, what cases will be denied without request for evidence, and what you can do to protect your case and still get your green card. Hello everybody, and welcome back to Immigration Channel. In this video, I'm going to explain to you the full details of a new policy coming from immigration. It's a brand new policy, and I've done a major video that talked about the beginning of this policy, but in this video, I'm focusing on one particular aspect that talks about the power that immigration officers now have to deny your cases without request for evidence, without a notice of intent to deny. As you know, when you file a green card case with immigration, whether it's a family petition based on marriage, or if you file for a parent or brother or sister, if the documents are insufficient, over the past 20, 30 years, immigration officer will simply send you a request for more information. Or if it's a really bad case, they'll send you a notice of intent to deny. Under this new policy, guys, this is important for you to understand. They're not going to do this anymore. They will simply deny your case flat out. And that's going to take you into deportation right away, immediately. So in this video, I'm going to break down 6 scenarios where it will cause immigration to simply deny your case versus before, just ask for more information. We're going to go over all these situations so you will never, ever experience a denial in your case because you're going to know what to do to protect yourself. So in this case, you need to watch this video all the way until the end because I'm going to go through all these scenarios one by one, and I'm going to tell you what to do to protect yourself and make sure that this doesn't happen to you. So let's start with scenario number 1, where immigration typically will ask for more information, but under this new policy, flat out denial. Number 1, insufficient proof of the relationship between you and the petitioner or the beneficiary. So imagine you are the immigrant and the US citizen is filing for a petition for you, either a spouse, wife, or a parent, and you need to prove that there is a relationship. So if it's a marriage, you have to have a clear, valid marriage certificate. You'll be surprised how many cases people provide marriage certificates that are not signed, that it's very difficult to read, or there's ambiguity if they're actually a real marriage certificate. But the biggest issues we see is between children and parents. There's no clear proof that this is your parent. Okay, so whether you provide a birth certificate or any other documents to prove that this is actually your family member, immigration typically will ask for more information. So if the documents that you provide are not good enough, maybe they're too old or they're not clear, you need to submit a DNA proof that you're trying to get relationship, you're trying to get a benefit from that person, whether it's your mother, your father, or if you are the person trying to file for your parents, you need to do that. Don't wait for them to ask for it because they're not going to ask for it anymore. So if the documents that you have, the birth certificates, the marriage certificates are not good enough, they're not, you can't read them, or they're not signed, or there's some issues with those documents. They were obtained from a country that there's a lot of issues there. Provide DNA proof just to be safe. Now, again, I would never recommend this before. It's too much. But under this new policy, if you submit something that they can't verify, they will deny your case. This is what they're going to do. It is happening right now. So when in doubt, submit DNA overkill to prove the relationship between you, the petitioner, or the beneficiary, because again, they're not going to be asking for this anymore. They will just simply deny your case. Number 2, incomplete or missing documents. When you file for your green card application based on family, for your spouse or parent, brother or sister, if you're not going to submit all the documents at the same time, they will deny your case right now. So for example, let's say you file for adjustment of status. You have form I-130, you file the adjustment of status form 45, but you forget the I-864, the financial support documents. Before, they would just send you a letter saying, hey, please provide form I-864 and the tax returns. Under this new policy, simple denial and you will be placed in deportation. You cannot afford anymore not to have complete documents. So Even if you cannot afford an attorney, you need to speak with an attorney to at least review your case. Okay, guys? Please. So if you need help to review your case, use the phone number here on the screen and send me a text and we'll help you. But do not send your case without being reviewed by an attorney, at least that, or hire an attorney if you want to make sure your case is 100% safe because you only have one chance under this new policy. Now, before we talk about number three, which is one of the big ones that we've seen, I'm going to ask you a big favor. You're watching my videos every single week. We make you guys the best videos on immigration out there with the most up to date information. We spend time to do it, but you're not a subscriber yet. Subscribe to our channel right now. Click the notification bell so you don't miss any of our videos. And also give us a big like so YouTube will be able to show these videos to more people just like you. As always, if you need help with your immigration matters, specifically now, it's super important that you speak with an attorney before filing anything with the government. Send me a text 619-483-4549 or go to www.immigrationasap.com. Leave your details and one of our team members will contact you ASAP. This is your chance. This is your time. Do it right. Now let's move to point number three, questionable bona fide marriage. One of the main reasons why many cases get requests for evidence every single time is because they don't have enough proof that this is a real marriage. Now you're going to need to do more. You're going to provide bank accounts, commingling of assets, lease, bills, pictures, put it in a big folder, as many as possible in the beginning when you file your case. Because if they're feeling that there's not enough, they might deny your case outright. Okay, guys? So don't take a chance. Put as many documents as you can to prove the bona fide of the marriage when you file this in the beginning. And don't forget your medical exam as well, because it is essential that you provide a full package when you file for your green card. Number four, guys, a big one, inadequate proof of financial support. Again, the most common requests for evidence we've seen are these. People don't submit the form correctly, form I-64. And when you do submit the form, it's never complete. They never sign it properly. They never provide the financial documents. They provide maybe one W-2, but you don't have the full tax return. I'm telling you guys, this is the number one reason why people get requests for evidence is the financial support documents, form I-64. Now with this new policy, if you're not going to get this right, your case will be denied. So I'll give you an example. Somebody's filing for a petition based on marriage. They're self-employed. They provide 1099s, all the documents, but it still doesn't look like they qualify because they deduct too much on their taxes. So there are different formulas. You can use your assets, or you might need a co-sponsor. If you don't provide this in the beginning when you file for your green card, they're not going to be asking for this. What they're going to do is they're going to deny your case and they'll place you in removal proceedings. So once again, as I mentioned to you, if you cannot afford an attorney, at least have an attorney review your final package. Use the number right here on the screen, reach out and take care of your case. It will be cheaper for you to do that instead of, whatever we charge, $750, $1,000 to get it reviewed. It's still cheaper than you being denied and going to deportation. If you can afford it, get an attorney to file your complete case, because then you know for sure you will not be denied and you'll have somebody on your side guiding you from A to Z until your case is approved. Do not save on this. Borrow money, do whatever it takes, have a lawyer file your case, because this new policy is designed to do one thing: get more people into deportation. And guess what? Once you're in deportation, it will cost you 3 times more to try to get out of this, hire an attorney. So do the right thing, hire somebody early on, and get this done correctly. Number five, inconsistent or incomplete information in your application. So, for example, you file a petition for marriage, you tell them on the I-130 that your address is in San Diego, but then on the 45, you have a totally different address, or dates of entry. Remember, these forms are lengthy and they ask you the same information over and over. And if your information is inconsistent, before they would ask you, hey, request for evidence. Why did you tell us this? Why did you tell us that? Now there's no more. They'll just deny your case. So make sure there is no inconsistent or incomplete information on the forms, because they're not going to bother with sending a request for evidence. They'll just deny your case. And number 6, I'm giving you an extra one: prior immigration violations. If you have a previous history of immigration, you filed previous cases, you were denied before, now you're refiling, or you were in court before, these things must be addressed properly when you file for the new green card. If you're not going to do it properly, if you're not going to disclose it properly, they will not send you a request for evidence. They'll not send you a notice of intent to deny. They will just deny your case and send you to deportation. So make sure that if you had prior immigration violations, you speak with an attorney before you file a new case, and make sure that everything is aligned and proper before you file a new case. These 6 things, guys, that I just told you are the main reasons why immigration sends requests for evidence before the new policy. Now that this new policy is here, they're not going to do this anymore. So you have to rewatch this video again, write down the 6 things I told you, and make sure you avoid them in your green card case filing. And the best thing you can do, guys, is at the end of this video is to share it with somebody that needs it. Also, subscribe to my channel again if you haven't done so, and send me a text 619-483-4549, and join www.immigrationsap.com. It's another way to contact us. But remember, guys, it is the best thing you can do for yourself. And I'll give you an extra one because you're watching my channel and you're here until the end of the video. I just released a free ebook, free guide for green card holders that are traveling and they are worried about coming back. The link to the free guide is at the description of this video. You download it, it's free, it's yours. Thanks for watching, and I'll see you in the next one.